Tree bark. Tree bark. A piece of tree bark is what prompted you all to be in court.
What you're about to see is one of those courtroom moments that feels almost unbelievable. Not because of violence, not because of money, but because of how far a simple neighborhood dispute has spiraled out of control. This entire case, which now involves multiple court appearances, criminal allegations, and stern judicial warnings, all started over one thing: tree bark. Yes, actual pieces of tree bark. At the center of this dispute are two neighbors, Daniel Calipari and Mr. Moss, whose ongoing feud has grown so intense that the court decided to hear both of their matters at the same time. That alone should raise eyebrows. Courts don't do that unless there's a serious pattern of repeated conflict, and in this case, that pattern includes hundreds of calls to police, accusations of harassment, surveillance, and escalating behavior that's drained public resources. As this hearing unfolds, you'll notice the judge's tone shift from procedural to openly frustrated. This isn't just about resolving a single incident anymore. It's about stopping a cycle. So as you watch, ask yourself, how does something so small turn into something this serious? Because by the end of this hearing, the court draws a very clear line.
Okay. And so, Mr. Calipari, your name for the record, please.
Daniel Calipari.
Okay. And so today is the date scheduled for Mr. Calipari for an arraignment pretrial and for Mr. Moss for a formal hearing. I understand that these are on two separate matters, but given the frequency of both of your visits to the court and the communications within the Riverview Police Department amongst yourselves, the court found it appropriate to have both of your cases called simultaneously. Mr. Shunke, as to the arraignment on your client.
Reading my client's things, dude.
Court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial counsel.
Be adjourned this matter for some comparison.
All right. So this court's going to adjourn this matter for compliance by Mr. Calipari. February 23rd. 4 weeks is February 9th. You're back that day. That would be 30 days. So we can do that day.
Wait a
9:15 a.m. Okay. The court's going to order a $3,500 personal bond.
This is a critical legal moment, so let's slow it down and explain exactly what's happening. When the judge orders a $3,500 personal bond, that does not mean Mr. Calipari has to immediately pay that amount. A personal bond is essentially a promise to comply with court orders, backed by money only if those conditions are violated. It's accountability without immediate punishment. Next, the prosecution moves to dismiss the littering charge against Mr. Moss. The reason is important. The judge recognizes that this dispute was not one-sided. The court explicitly states the conflict appeared mutual in continuing to prosecute. Only one party would not be in the interest of justice. This is the court attempting to de-escalate the situation, to remove fuel from an already volatile dispute. But as we're about to see, even legal leniency doesn't guarantee emotional restraint.
Now, let me be very clear. So the people are moving to dismiss Mr. Moss's charge of littering, correct?
That is correct, Your Honor.
And this is a result, I believe, of the tree bark at issue with Mr. Calipari's criminal charge of assault and battery, correct?
That is correct, Your Honor.
Okay.
Just for the record, I believe there was a dispute between the parties, and it appeared to be mutual, so we, the case against Mr. Calipari is dismissed, and we thought it would be in the best interest of justice to do the same for Mr. Moss.
Okay. Did you two hear that?
I did.
And what part of that did you hear?
The entire thing.
Okay. Tree bark. tree bark, a piece of tree bark is what prompted you all to be in court.
This exchange is where the judge's disbelief becomes impossible to miss. The repetition of the phrase tree bark isn't just emphasis, it's a reality check. The court is openly questioning how something so ordinary escalated into criminal proceedings by comparing the situation to a leaf falling on a car in a parking lot. The judge is testing reasonableness, which is a cornerstone of legal judgment, and the answers reveal the core issue. The response simply doesn't match the event. This isn't about damage, it's about fixation. What we're watching here is the legal system pushing back against overreaction. The judge isn't minimizing frustration, but they are drawing a line between inconvenience and criminal behavior. So here's the question for you. Would you have reacted the same way? Or is this a case of a minor annoyance turning into a major legal problem?
Tree bark. Because somebody didn't like it on their car. Who cares? Who cares? And who cares what tree it came from? Is it really that important? Mr. Moss, is it really that important?
Sir, I have no trees on my property, it is.
So if you're at a store, sir, and a leaf falls on your tree, or on your car, what do you do about it?
Okay, but we're gonna talk about it's a tree bark here.
That wasn't my question.
A leaf is nothing, but we're talking about numerous pieces of tree bark in this instance. Yes, only one placed on a vehicle, but still numerous pieces of tree bark over time.
Sir, again, if you were at a store, say a piece of tree bark fell on your car when you were at a store, what would you do?
I believe it.
Right. Would you call the police?
Not if I was at a store.
What's that?
Not if I was at a store.
Okay, and you would remove it. Where would you put it?
I don't know. I'd probably either inside my vehicle so I could get rid of it, or, depending on conditions outside, maybe back outside. I'm not certain. It would depend on the moment.
Okay. Mr. Calipari. What about you?
Your Honor, this isn't about tree bark. This guy has been.
That wasn't my question. Because clearly the two of you are so antagonistic of each other that you drain the resources of the Riverview Police Department. Over 800 calls have been made in less than 5 years.
This is the moment the entire hearing changes tone. Over 800 calls to the Riverview Police Department in less than 5 years. That number alone explains why the court is no longer being patient. Emergency services are not designed to resolve personal vendettas, and the judge makes that painfully clear. Both parties are called out, antagonizing behavior, surveillance, repeated complaints, escalation on all sides. This isn't just about annoyance anymore. It's about misuse of public resources. That's why the court issues extremely specific restrictions: no filming, no live streaming, no contact, no commentary, and no police calls regarding each other. These aren't suggestions. They're enforceable boundaries meant to stop a cycle that has clearly gone too far. When a judge speaks this directly, it's a warning. The next violation won't come with a lecture. It'll come with consequences.
Over half of which involves specifically Mr. Calipari. But Mr. Moss, you contacted the Riverview Police Department over 800 times via 911 and 9 emergency lines. There are definitely not 800 extremely urgent, life-threatening emergency situations that would have prompted you to contact the Riverview Police Department. Mr. Calipari, you 100% antagonized Mr. Moss. If there is tree bark anywhere, who cares? Who cares? Do you have a leaf blower?
Yes.
Great. Blow it off your lawn. Onto the street. Or pick it up and put it in the trash.
Right, but yes.
Do not continue conduct yourself in such a fashion that you're going to antagonize Mr. Moss. And I'll state for the record, Mr. Moss submitted a video. I don't remember at what point there was a video. It was silent because I think he may have been recording or something at the same time. I don't know. But Mr. Moss was videotaping your house. He was videoing your house, Mr. Calipari. And yes, while it's frustrating, it's all of those adjectives. You come out of your house and then you come right to the property line. And you're running your mouth saying something I don't know because there wasn't a volume. Why even leave your house to go confront Mr. Moss?
Your Honor, we don't have a doxing law in this state, but he's doxing me.
Okay, excuse me, just one moment. Do you think that by going and speaking to him, he's going to stop?
Yeah, no.
No, so why bother? Why bother? If you think that there's a violation of a law, then make a police report. If you think that Mr. Moss is doxing you, which I believe that there is something in the statutes regarding that,
I've looked, Your Honor.
then,
I don't think there is.
well, if you make a police report, sir, and the police officers send it to the Wayne County Prosecutor's Office, they'll do their research to determine whether or not there's a charge. I don't know. But that's how something happens for a violation of a law. It doesn't do there's zero benefit by going over to the property line other than it's going to prompt another police report, another case, and you two coming back to court. If you two want to visit the court that often, come by whenever you want. It's open. You don't have to wait till you have a criminal case here or a civil infraction. Come whenever. Come whenever. Let me be very clear, Mr. Moss. Mr. Calipari has been given a citation regarding some of the issues that are going on. I believe it's in the back of the house. During this adjournment period, there is not to be any communication with anybody working at his house or with Mr. Calipari or any videoing of Mr. Calipari doing his work. You're not to live stream any video of Mr. Calipari doing work in the backyard. Am I clear on that?
Yes, Your Honor.
None. Zero. Not a live stream, not anything. Oh, here's Mr. Calipari finally doing what he's supposed to be doing, or whatever else is going to be. Not happening. Not happening. There's not to be any calls to the Riverview Police Department regarding Mr. Calipari's home within the adjourned period of time either. Are we clear on that?
Yes, Your Honor.
Mr. Calipari, if Mr. Moss is doing any of the things that I just stated he is not permitted to do, which is going to be put into a written order, don't address Mr. Moss. Contact your attorney. Contact your attorney. Or then your attorney will contact the prosecutor that can file whatever motion needs to be filed. Am I clear?
Yes.
Yes.
Yes, Mr. Johnson.
Your Honor, just in light of what has been going on, I would just like to place on the record that should anything come back through this court, the city of Riverview will look to prosecute to the fullest extent of the law. There will be no such consideration of things, so I just want to make sure that's prosecute to the fullest extent of the law.
All right, thank you. Do you both hear that?
I did.
Yes.
By the end of this hearing, the court makes its position unmistakably clear. Charges are dismissed to de-escalate the conflict. A personal bond is imposed to ensure compliance. And strict no contact and no surveillance orders are issued. Most importantly, both parties are warned that any future violations will be prosecuted to the fullest extent of the law. This case is no longer about tree bark. It's about boundaries, accountability, and knowing when to stop. The judge gives both sides a chance to reset, but also makes it clear that the courtroom will not continue to serve as a battleground for personal disputes. Now we want to hear from you. Did the court handle this fairly, or should stronger action have been taken sooner? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.